Mediation can be opted for at any stage. Even before the parties have been to their attorneys, they can opt for mediation up until the point where the judge is ready to deliver judgment. They can still say, Your Honor, Your Worship, please do not deliver your judgment now. We're ready to mediate. They can go and mediate then at that very late stage, come back to court with a settlement, a written settlement agreement that can be made an order of court. So throughout this whole process of litigation, at any stage, can parties opt for mediation?
Laurie, mediation is something new to South Africa. It's not something that's been here for a long time. So lots of South Africans are not used to it. They don't know it. How can mediation help couples to have resolutions for their problems?
Good. So the Office of the Family Advocate was established in the late 80s, 1987, 1988. Through a piece of legislation that is known as the Mediation in Certain Divorce Matters Act. And that brought about the Office of the Family Advocate. And initially, the Office of the Family Advocate was involved in helping couples who went through divorce just to deal with their children and to take care of the principle of the best interest of the children. Then a couple of organizations, private organizations of mediators were established across the country. There's one in Johannesburg, there's one in Cape Town, there's now one in KZN, and the one where I'm involved in, we do work across South Africa. So people who go through a divorce, who go through relationship breakdown, people who have any kind of family dispute can opt for mediation. The traditional process is litigation. That's where you go to your attorney or you go to a court and you start, you open a case. With mediation, as I've said previously, at any stage, you can approach a mediator, a trained, accredited family mediator. And that mediator will help you to resolve disputes out of court, out of the public eye. It's a confidential process to start off with. In most of the cases, there's absolute confidentiality. In some family matters, there are some limitations when it gets to abuse, child abuse, and so on. But mediation is a voluntary process. Both parties must be willing to submit to the process of mediation. Recently, we had some amendments to the High Court rules and also to the lower court rules, the Magistrates' Court rules, which makes mediation not mandatory, but before you can take your case to court, you must show the judge or the magistrate that you have tried mediation and that mediation was not successful. Now that helps a lot to bring down the number of trial matters on the court rolls. The beauty of mediation is that it's an empowering process. How does it empower the parties? The parties remain in control of the outcome of their own case. So what does that mean? They can decide what they want. They can structure the outcome of their agreement, even the court order. If they happen to be in a court of law, they hand their power over to a judge or a magistrate who's going to make decisions on their behalf about their family, about their assets, about their children, and so on. Mediation is a neutral process. The mediator is an impartial and neutral third party. The mediator cannot make decisions on behalf of the parties. The mediator cannot make decisions about the law, cannot make any decisions about the facts of the case or the credibility of the parties. In other words, who's telling the truth and who's lying here. And then through mediation, it's possible to reach unique solutions. What does that mean? It goes hand in hand with that empowering. Your circumstances are unique. Your family is unique. Your children are unique. Maybe they have special needs, and you can custom-made the outcome for your own family.
Laurie, you say that you can ask for mediation at any stage during a feud, but in your experience, when is the best time for a couple to say, listen, I think we must go for mediation?
As soon as possible. Really, as soon as possible. It saves a lot of time. You can have your case mediated within 2-3 days. You can have a settlement within a week. It saves you money. Litigation cost is extremely expensive. I've mediated cases where the cost of litigation ran up to 8 million rand. And then in one morning, I sit down with the parties, family matters, and at the fraction of their legal cost, I help them to create their own outcome, to draft a settlement agreement which is made in order of court.
What is the cost for mediation?
Okay, so we have a registration fee. There's one person usually refers the matter to mediation. We call that person the referring party. So he pays a registration fee of 670 rand. And that will include all the emails and telephone calls and the admin around dealing with his or her matter. Then we get the other party on board. If the parties are on speaking terms, they can approach the mediator together. Once both parties submit to mediation, both of them make a contribution towards the cost of the mediator. Depending on the complexity of the matter, the fee may vary. My standard fee for mediation is 1,200 Rand per hour. I need approximately 2 hours for my first session. I settle up to 80% of all disputes with only one session, 1 2-hour session, at the cost of 2,400 Rand. Another 10% of cases, which are more complex, will need a second or a third session. And then 10% of cases do not settle through mediation. And this is a statistic that is available, and this is a phenomenon worldwide. So 90% of cases that do submit to mediation will settle through mediation.
So it is really a much cheaper process than going through court.
It cannot be compared. There's no comparison. If you go to an attorney today and you say, I want a divorce, he will probably tell you, well, you need to deposit 15,000 Rand. I will open a file and I will have the first consultation with you. So you start off in that way. I've dealt with so many cases in my career as a mediator where parties have started out with litigation. They go to the attorneys, they start the litigation process, and then there's a saying in our country, don't talk to me, talk to my lawyer. So the first thing is the attorneys prefer that the parties do not talk to one another, and to rather speak through the attorneys. Mediation is quite different. we introduce the parties, we reintroduce the parties to one another. We encourage them to start talking to one another. And that's the way how we settle disputes. Most of the disputes, or many disputes rather, is because of a lack of communication. So we help the parties to communicate, and a good mediator will work himself out of a job time and again, because he reintroduces the parties to one another.